statement not covered, but some courts have held that the authorization to make the public statement may not be covered either. It's a very technical and interesting issue, and it's before a great judge, Judge Kimball Wood, who I remember as a student at Harvard Law School, is brilliant, sophisticated, courageous. She was the judge who put Michael Milken in prison and then reduced his sentence. She's had a lot of experience, and she doesn't take any nonsense from lawyers. I think it was a terrible mistake of Michael Cohen's lawyer not to have Michael Cohen in the courtroom, but being videotaped, you know, smoking cigars as if it was a scene out of Billions. You know, you don't do that.
That's
you
deliberate. By the way,
lawyer,
that's a choice. Michael Cohen doesn't stand outside smoking a cigar by mistake.
You bring your client into the courtroom. He looks deferential. He wears a tie and a jacket. Shows respect for the court.
Let's just finish up this legal argument here, because the government's case in the footnotes, when you read the government versus Michael Cohen, this whole document that is now out there, is that Michael Cohen wasn't really doing any legal work for anybody, or much of any legal work at all. So they seem to be suggesting here that none of this communication
I don't think that's right. Lawyers' work is very broadly defined. It's not just going to court. It's making deals for clients. It's helping clients out. I can easily imagine a phone call, I'm just imagining this, from the president to Cohen saying, you know, the Access Hollywood tape, it was probably illegally obtained. I didn't know the microphone was on. Can you stop it? Can you do anything legally? Sure, that would be a lawyer-client communication. So I think the government overstates its case. I also think the government has raised some questions. Do you invade a lawyer's office and risk the privacy of his clients when the crimes being investigated are not terrorism, organized crime, very, very serious matters? A sense of proportionality always has to be used when you raid a lawyer's office, a doctor's office, a priest's office, because you're talking about the potential of a taint team, which are government agents, reading confidential material.
And we've heard your concerns over the last several days on that, and I think a lot of people who watch any variety of cable networks have seen you, in some cases, not defending the president, but perhaps standing up for the president's legal rights or talking about the boundaries of the investigation. Right. Hang on one second, but I think what's notable this morning, what people should hear, is you think that in this instance, insofar as there is an investigation of Michael Cohen, this is where there is jeopardy for the president.
Oh, I think that's very much the case. I've said for months that he has much more jeopardy concerning his pre-presidential business and personal activities. And one of the reasons I'm standing up for the president's civil liberties rights is because the ACLU has fallen asleep on the job. They actually came in and issued a statement justifying and defending the raid without raising issues about client's confidentiality. And when nobody else is defending the civil liberties of the president, this can establish precedents that could affect us all. So I have to stand up for human rights and civil liberties for a man I didn't vote for.
But that defense only goes insofar as you're talking about those civil liberties. You are not actually saying there's not a problem here for the president.
I've always thought there's a problem.
And that is specifically what here in this case?
The specific problem is his pre-presidential activities, which are not within the scope of the special counsel. His real problem is not with the special counsel now. His real problem is with the Southern District of New York, which is less visible, does things less under the radar than the special counsel. And I think his priorities of his defense team, I'm not part of that, has to shift now to focus much more on New York than Washington.
And his argument, because his team is now part of this case, do you think it will be or should be successful that none of this evidence collected by the FBI should be admissible?
Well, look, admissible is one thing, but reviewable by the government is another. What I would think the best protection of civil liberties would be for Judge Wood to take all the material, read it herself. She's trustworthy. She's not going to leak anything. Determine which is covered, if anything, which is not covered. What's not covered turns over to the prosecution. What is covered is given back to the lawyer and his client.
But the important thing is here, you think that some of it would and perhaps should be admissible here.
If it's not privileged and if it was legitimately obtained by a legitimate search warrant, traditionally it gets admitted into evidence.
How nervous should that make the president this morning?
It should make him nervous about his lawyer, who he spoke to and called. I don't know. He knows. I don't know what's in those conversations and whether he should be nervous about what is in conversations between him and his lawyer that may not be privileged. That's the concern.
Professor Dershowitz, always a pleasure to speak to you. Thanks so much for coming in.
Thank you.
Enjoy the good weekend here.